as such, so we shouldn't be required to do an entire probate. We should just be able to get an order from the judge putting the property into the trust. Well, lo and behold, the court bought the argument, it went up on appeal, and the appellate court certified it. And in essence, what happened was a huge change and a shift to the law, which is very beneficial for the heirs when they're trying to move assets of the decedent that aren't properly titled, okay? So that's what happened in Hegstad, and it was codified in the probate code. So we actually now have a probate code statute that codifies that. Now, one of the ways to help prevent this, and I passed around a couple items what I'm going to talk about right now. So if you guys would pick up the little, looks like a little business card, okay? This is called a Billfull Card. So Billfull cards are very important. If you read the card, and I'll read it out loud to you, it says, please place the name of title of the real property or account in the name of John Smith, trustee of the John Smith Revocable Trust, dated January 22nd, 2018. If any questions arise, contact, and it has my name and my firm address and phone number, okay? Billfull cards are incredibly important because if I'm doing an estate plan for a couple that's in their 30s, they're gonna live, God willing, numerous decades after that. They're presumably gonna acquire more property. They need to have these because whenever they buy something else or any other asset that has to be titled in their name, all you have to do is provide them with this card, and then the asset will be properly titled. That's one of the ways to prevent the problems that I discussed earlier about newly acquired property, right? Is by the proper use of the Billfull cards. When I do my estate plans, these are included in all of my estate plans. And it also has my contact information. So should the person who's trying to title the assets have any questions, they can just contact me, okay? So this is one way to do that. And one important disclaimer, if you look at the back, if you turn the card over, you don't want to change title to any tax-deferred accounts, because if you change title to tax-deferred accounts, it could possibly trigger taxation. So that's why this is on here too. So if you try to change your 401k or whatever other type of tax-deferred accounts, don't do that. That's why it's in all bold and all caps. So you don't want to do that. Another way to prevent this from happening, if you look at the sheet of paper that I handed out, this is the Schedule A. Generally every trust has a Schedule A to it. Schedule A is your schedule of assets, or what a lot of financial planners call financial statement. This right here is what's going to help you. If you look at the part, it says assets listed on this Schedule A are for the purposes of illustration and record keeping. All assets of the trust may not be listed here, and this Schedule A shall in no way be construed to limit the number or amount of assets held by this trust. The Schedule A in no way shall be used to determine the status of assets of community or separate property. And then it goes on to list the assets. Well, one of the assets is all real estate, and then I specifically put the property that's known at the time. That way, should we have any of these titling problems, okay, you show this and the signed copy of the trust to the judge, and you can easily use the Hegstad case, which is now codified into law, to promptly get the asset into the trust, okay? Now, the benefit is, you can use a boilerplate language like all my real property. Now, I use that, but I still like to put the exact address of the property just to be safe. Sometimes you never really know what a judge is going to do, so I kind of like to go a little overboard where I'm slapping the judge in the face with it, right? So not only does it say all real estate, the address is listed right there. What's the problem? Now, one of the issues that you have, in the case I got referred from Hilda, they had a Schedule A that had a signature on it, but it wasn't signed, okay? So that's a problem now that we have, and they didn't have a pour-over will. Now that's another piece of the estate planning puzzle that would help you, which is basically a will that says everything is supposed to go and be titled to the trust. So those are just a few ways to avoid the Hegstad problem. So one of the things that you should look for if you encounter any of these situations, so if you run into someone and they're trying to change title to the property, they're trying to sell the property, and they can't because of this problem that I told you about, the key things that you want to look for is the living trust, the Schedule A, and the pour-over will. Those are the key documents that I need to see to make sure that they can qualify for this Hegstad solution. again, living trust, Schedule A to the living trust, and pour over will. Those are the key aspects to that. So I'll end right there, and if anyone has any questions, please feel free.
Any questions?
Yeah, go ahead.
So I'm assuming that the best time to go and review these things is before this becomes an issue. So would you advise that if someone owns property today, if they're in their mid-30s or whatever, whatever age, that this is something that they should be looking at today and not wait for it to be a problem?
Yeah, most definitely. One of the things that you want to do when you have a trust is every 3 to 4 years it should be reviewed regardless, just because of changes in the laws. Additionally, any key changes in your life, so for example, any newly acquired property, if any of your successor trustees pass away, let's say you have an older brother who's going to be your successor trustee and he passes away, that's something else that we should know about, because we might want to change the whole setup of your living trust. God forbid if you have any of your beneficiaries or your children pass away. That's also something that we need to do. So basically every 3 to 4 years, or any major change in assets or family members who are part of the trust, you should definitely consult an attorney and have your estate plan reviewed. Yeah, right?
All right, Dorian, I got a question about why is a will not equal to a trust? Why do you need a trust in addition to a will?
Well, that's an excellent question. That's another article that I wrote, 3 reasons why a will doesn't really help you. The problem with the will is it's so well known. We see it in movies, we hear it in music. Everyone talks about a will. The thing that everyone doesn't realize is a will still has to go through probate court. So you don't really save yourself the hassle of probate, because a will still has to be probated. If you have a trust, you bypass probate entirely. The only thing that you want of a will in conjunction with a trust is to pour it over. And what that means is the will indicates that you are devising all of your assets to the trust. That way, instead of going through a full-blown probate, which is 9.5 months to a year and a half, which you would have to do for a regular will, you're merely going to the court and saying, look, Your Honor, all of the assets that are not titled in the trust, according to his pour-over will, should be titled to the trust. And at that point, you get an order, and it's very expedient. You're talking a few months versus 9.5 months to a year and a half. So that's a very big difference. And also, it's a big difference in terms of cost. You guys know, working in the real estate industry, right now, the real estate industry is really hot. Property is going up. LA County probably on average is about $500,000 to buy a home. If you have a $500,000 home, that's, let's see, that's $13,000 attorney fee, $13,000 executor fee, and you figure probate cost, you're looking at close to 30 grand, okay? Whereas I charge generally flat fee of $4,000 for trust administration. So that's a $26,000 savings. And if you have a will, those fees are applying. Whereas if you have a trust, much more expedient and a lot cheaper.
So if the property's worth $1 million, it would cost you twice as much in probate.
I think $1 million is something like $29,000, and then once it's over $1 million, it has to be approved by the judge. But it's going to be a much larger figure from there. Hold on, go ahead, Ryan.
Can you explain just like what is probate exactly? Can you explain that?
Yeah. So how do I say it? So probate is a certain type of court. We have different courts or jurisdictions of courts. So we have civil, criminal, family, and probate, right? Then we have unlawful detainer. There's different types of courts that sit in different jurisdictions. The point is they resolve certain particular types of matters, okay? What probate is the administration of estates primarily. There's also other things that probate handles, like guardianships, conservatorships, but primarily it's going to be the administration of estates. And the reason is, if you die without an estate plan, how do we deal with your property, right? What do we do? If you don't have a probate system, then there's no way to deal with that property. So basically, whether you like it or not, you have an estate plan, and it's one that's created by the state of California, which you may not like. So if you don't like that, then you have to create your own estate plan. But one way or another, there is an estate plan for you. And if you don't create one, then it'll go through probate, as will a will, and that'll be administered through probate and supervised by the probate court until it's complete. Go ahead, Peter.
I got one more question.
Yeah.
You always talk about your kids when they turn 18. What is
Yeah.
the paper that needs to be notarized and signed for your children so that you can say what happens to them if they're in a bad accident?
Right. So that's another excellent question. What you need to have, everyone over 18 should have a power of attorney and advanced health care directive. I'll give you one example that's very personal. A good friend of mine, a good friend of hers died at 25 in a really bad traffic accident. Now, obviously, no one thought she was going to die at 25. It's really young. The problem was the family wanted to get a bunch of her pictures off of Facebook, and Facebook wouldn't let them. So they had no ability to get the pictures from Facebook, no ability to access any accounts that she had, because there was no power of attorney or advanced healthcare directive. Now, the reason you need those documents is should anything happen, okay, you're going to want to be able to take care of your children, because as parents, your children are always going to be children in your eyes. I mean, I'm 41 years old. My mom still calls me kiddo. Okay, she's going to call me kiddo until she dies. That's just how it is. What am I going to tell her? She changed my diapers, right? So your parents are always going to look at you like that. But the reality is at 18 years old, you're an adult in the eyes of the law. So if anything happens, you don't necessarily have a right to go into the hospital and make medical decisions. That's why you need the advanced health care directive. So at the very least, everyone over 18 should have those, particularly if they're going to college, because if they did half of the stuff that I did, they definitely need an advanced health care directive and a power of attorney. Any other questions? All right. Well, thank you much, everyone, for your time, and I hope you guys learned a little something.